wait, hold on. To be fair, okay? I mean, Pixie was the one that made this public, right? Like, you realize that, right? Pixie was the one that made this public. Like, the part that you're redacting her full name out, but I'm just saying to you right now, Jstlk, like, Pixie is the one that made this public. So I want to see, what I want to see, okay? I want to see you condemning Pixie, okay? I want to see you condemning Pixie. Stop. This stuff is performative, okay? Radiant. No, he's doing this performatively, okay? He's doing this performatively. Alright? Yeah.
This one?
100%.
Okay. All right. From Melina. Okay. So,
like, you can't tell me the kind of person who, like, literally, like, fucking dances around, like, fucking Destiny's docs is the person who suddenly cares about, like, whether or not someone's doxed or not on a fucking court document when it's literally a public court document. It's so fucking stupid. No, I'm just, I know, I'm just saying.
All right.
Like, yeah.
Plaintiff Jane Doe, by and through the undersigned counsel, hereby respect.
Like, I don't think Jstlk gave a fuck when Rose got doxed, so yeah, like, why pretend now?
Respectfully files this unopposed motion for the issuance of a letter of request to serve a subpoena to testify and produce documents on Melina Blank Goranson, resident of Sweden, pursuant to the Hague Convention on taking evidence abroad in civil or commercial matters, 23 UST 25 whatever. Plaintiff states as follows: a letter of request, also known as a letter rogatory, is a document issued by one court to a foreign court requesting that that foreign court take evidence from a specific person within the foreign jurisdiction or serve process on an individual or corporation within the foreign jurisdiction, and to return the testimony or proof of service for use in a pending case. Cool. Letter of request, Black's Law Dictionary, 11, okay. Letters of request are the means by which a court in one country requests a court of another country to assist in the production of evidence located in the foreign country. Okay, cool. All right, that kind of, I mean, that makes sense to me. It's weird that anybody could think it's something different, given this document existing. See also Federal Rules of Civil Procedure 20.
Wait, does anybody know whether or not Jstlk covered Destiny's new document?
28B, page 28B. Art 28B? No, that's procedure. Whoops. Rules of Civil Procedure. So, permitting federal courts to issue letters of request to foreign countries. Okay, both the issuance and enforcement of letters rogatory, rest entirely upon the comity of courts towards each other. Comity. What is this word? An association of nations for their mutual benefit.
Comedy.
Ooh.
Nice.
Comedy is the, recognition which one nation allows within its territory to the acts of another nation, having due regard both to international duty and convenience and to the persons who are under the protection of its laws. You're a tad quiet? I'm not really speaking directly into the mic. I'll be better about speaking directly into the mic. Okay. So this is, like, basically nothing, in my opinion. I don't even know that this would be... So it says it's relying on comedy, right? So it's entirely possible that they serve Melina and do nothing outside of that. They just go, hey, you've been subpoenaed here, right? They might do that, but it might have no power whatsoever. I don't know. We have no idea. So
starting to get pissed? I hope
relevant
so.
Factual back... I mean, this is just going to say... I think they basically cite authorities for why they can do this. I know that this is possible. It sounds like this is entirely like anything you'd have, any protections you'd have in Sweden, you would keep. So if she doesn't have to testify in like civil court cases in Sweden or something, it'd be fine. Like she just could ignore this. All right. Let's see. The action involves the non-consensual disclosure of intimate images under the federal statute commonly known as CARDI, 15 U.S.C. 6851, as well as a claim for violation of Section 784049 Florida statute for sexual cyber harassment, intentional infliction of emotional distress, and invasion of privacy. More specifically, plaintiff alleges that multiple times, but okay, this is just restating all the stuff. The need for international discovery. So argument, the need for international discovery. The sought-after discovery from Melina Goranson is relevant to the claims in this action, will likely prove highly material to the prosecution of this action, lead to admissible relevant evidence, and is proportional to the needs of this case. Goranson is the former spouse of the defendant, Stephen K. Bonnell, and is uniquely positioned to provide evidence of the conduct complained of in the AC, in the initial complaint, right? AC? Not actual complaint. What would this be? AC. Something complaint. Fuck. Now I want to see. It's not initial. Oh, amended complaint. Amended complaint. I got it. Listen, steel trap up here in my brain. All right? As well as similar conduct that she was a witness to. By way of example, Goranson is the recipient of certain sexually explicit materials involving plaintiff. Goranson is expected to corroborate plaintiff's allegations, including those allegations regarding Bonnell's lack of consent to disclose the video. Moreover, Goranson is, or is believed to be, another victim of Bonnell's unlawful conduct. Finally, Goranson would testify to Bonnell's character as it is relevant to this case. Indeed, Goranson is expressly mentioned in the amended complaint as a relevant witness. Docket entry 120, paragraph 34. Okay. So it's saying they cite this for there's some case where granting plaintiff's motion for a letter of request in concluding that the sought-after discovery is relevant to the plaintiff's claims and may prove material to the prosecution of the action or lead to material evidence. Okay, so it sounds like there's no reason that you'd expect the court to deny this, and I'm also expecting that this probably went through meet and confers, and I would expect Destiny has no plan to, like, Andrew Brettler has no plan to oppose this. Seems most likely to me, right? Andy B wouldn't have any reason to want to oppose this. Oh, also,
Yeah, why would he oppose this? It's fucking retarded. Why would he oppose this? It's fucking retarded. It's like, how, well, why the fuck? Like, can anybody tell me why the fuck, like, Jstlk is treating this as if this is, like, a normal fucking request? Like, I can't believe it. Like, this is, like, clearly not a fucking normal request, right? Like, this is obviously a ridiculous fucking phishing attempt in order to get some dirt on Destiny, right? By trying to subpoena Melina... subpoena Melina, that rhymes, okay. Subpoena Melina internationally, right? Like, this is obviously one of the most stupid, most rancid, most dysgenic things I have ever seen in my entire life when it comes to legal shit, okay? And I've seen some crazy shit. In the sense that I've seen very little, okay? But this is still crazy, okay?
Guys,
okay,
if you're watching on Twitch, head over to Kick, all right? We're going to go Kick only for the rest of the stream. Love you guys. Thank you to all the Twitch viewers. Head over to Kick, kick.com/JSTLK. We'll see you there in just a little bit.
Wow.
Bye-bye. All right. Alternative means of obtaining the sought-after evidence are unavailable. Moreover, this evidence cannot be obtained by alternative means because Goranson's knowledge of the facts relevant to the case is unique and central to plaintiff's allegations. However, even if it were available by alternative means, for the sake of argument, the mere fact of an alternative method for obtaining the documents is not proof that it is necessary and effective or efficient method for doing so in this case. Hague Convention, balance of interest among nations, proposed letter of request is in here. Okay. For the foregoing reasons, plaintiff respectfully requests that the court approve, date, sign, and seal proposed letter rogatory to the Central Authority of Sweden to serve as a subpoena on Melina Goranson to testify and produce documents in accordance with the Hague Convention on taking evidence abroad in civil or commercial matters, which is submitted concurrently herewith.
Honestly, the case has gone on for way too long. Well, you have to keep in mind, like, this is, like, how court cases go. Like, court cases are extremely slow. Like, the judge and, like, the fucking public, like, fucking clerks and shit like that, they only have so much time to contribute towards this. Like, yeah. Like, they're probably, like, I don't know how much fucking cases they're working. Like, okay, hold on. How many federal cases do federal courts do at the same time? Okay, get ready. You guys will not be able to handle this. This number, okay? Wait, no. One court. One court. There's one. Okay, never mind. It's not... That's crazy. So apparently a single federal court can hear over 300,000 civil cases annually. Yep. Okay, well. 300,000. A single court.
And for the clerk to authenticate the court's signature by affixing the court's seal thereto, and that the letter rogatory.
What the fuck?
Wow. Cool. Dude, is every legal case this fucking dumb? I don't know. Like, is this dumb? I guess I would need to know why you think this is dumb.
ADHD, hell, yeah.
Melina said stuff was shared of her non-consensually twice now, both at the Bob 7
Was Foodies rated by a certain predatory gnome? Yeah.
time and this stuff. Did they change the text after submitting? Oh, wasn't that... Hold on, what is Saiba saying? That was for another one. They changed the text on a different motion. Yeah, is a different one. Anyway.
Imagine sitting and reading and writing papers for 10 hours every day. Well, some lawyers try it and they just don't like it. Like, obviously, because I don't know, maybe you have like this fucking glorified picture in your mind where you kind of think of yourself as like the fucking, oh my god, I'm gonna be the next fucking like Saul Goodman, right? But then like you're actually getting to court and you're like, oh fuck, this is actually really fucking boring and tedious. Which is probably why my statistics fucking teacher back in high school quit his fucking lawyer job to become a teacher. Yeah.
None of this seems
Alright.
weird or, like, wrong to me, so, yeah.
Wow.
Okay. All right. Cool. And this was the, this is the actual letter of request. Okay. All right, so that's
Next
basically
Chuck
nothing.
McGill, sure.
Let's go back to the docket. So I think that's the only thing we're not going to cover. Oh, also the original technical expert refiled, or sorry, he amended his filing. Right? That might be relevant. Maybe it's relevant a little bit later. I'm not sure. We'll see. What is this? Off topic, but what is this?
I want to kill him. I want to kill this dog sometimes.
No, stop.
Fucking Christ,
Don't say
dude.
that on stream.
Oh!
What?
Yeah. Well,
Yikes.
if that
Wait, that's it? Oh, no. Never mind. No. There's
that's
more,
not
there's
something
more.
you've thought about your
There's more.
dog when they're doing something super annoying, I don't know what to tell you. Obviously, you don't do it. May 27th? Oh, May 27th. So that's showing the VOD could be from May 27th. Okay, cool. Cool.
Jesus.
Okay, so this is probably the thing we're going to focus on.
Friendly
today,
as Hassan
is the
Dogflip.
reply
I
and
know,
support of
right?
motion.
Oh.
This guy's out here today. Let me make sure that this is showing up well on stream. Oh, it's a little too small. Hold on. There we go. All right. Have a good night, Cybo. See you later. Dog was interrupting his stream like a DDoS kid. The dog had taken a blade of grass one too many times. It had
Nice.
to go, okay? It was over for that dog. All right.
Ha
Okay.
ha. I guess. Jesus.
All right, Maximus says if anybody's interested in hunting for that Hassan VOD, you can head over to the Discord. He's going to be looking in there, okay? So, introduction. This is just so we're clear, Destiny filed a motion to dismiss on subject matter jurisdiction grounds. Pixie had a response, and now Destiny is following that up. Destiny's lawyers with the reply in support of his motion to dismiss the amended complaint. All right. So, introduction. This court lacks subject matter jurisdiction over this dispute, and plaintiff's opposition offers no evidence whatsoever to cure that fatal defect. Indeed, in the court's October 6, 2025 order denying plaintiff's motion for preliminary injunction, Magistrate Judge Torres warned that if plaintiff cannot show in due course that the conduct alleged is indeed covered by the statute, it is possible that we do not have subject matter jurisdiction over plaintiff's case. Plaintiff's opportunity to establish jurisdiction has come and gone. That's not what he's saying here. That's the judge saying, hey, given that this motion is filed, it would be inappropriate for me to make a comment on this. I'm just going to say, hey, this is a possible outlying issue, and they filed a motion on it. That's not what they're saying. Why go to court and just lie? The judge knows what he meant when he said these things. Oh wait, hold on. I think this is Jacqueline Becerra would be looking at these ones. So this one, I don't think this one's remanded to a magistrate judge. This is going to be a different judge. So I don't know. This just looks like a lie. This is just a lie. But I'm sure the judge will look at it and see that the what would you say? The U.S. District Court judge will look at it and see that the magistrate judge was saying that I'm not going to rule on this because of this motion, and that I'm not commenting on the merits of the case. Anyway, the burden rests on her to establish jurisdiction, yet since filing the complaint in February 2025, plaintiff has failed to produce any evidence to demonstrate that Bonnell transmitted the video after the effective date of the Cardi statute. The record demonstrates that Bonnell sent the video on a single occasion to a person named Rose in April 2022, months before Cardi took effect. Despite having nearly 8 months to conduct discovery, plaintiff has failed to proffer any evidence to the contrary. Notably, in just the last few weeks, and with the discovery deadline looming, plaintiff is scrambling to establish subject matter jurisdiction, engaging in a frantic fishing expedition, including by seeking relief under the Hague Convention to obtain wholly irrelevant documents from Bonnell's ex-wife in Sweden. Plaintiff should have established subject matter jurisdiction before filing her lawsuit in federal court, rather than desperately seeking evidence of jurisdiction 8 months later. Having failed to meet her burden, plaintiff's claims must be dismissed. Now, again, do you need to have proof that the crime happened, like proof positive that the crime happened, to obtain subject matter jurisdiction? Would be my question.
Oh
I don't know what the
my
burden, like the level of.
Oh my god, dude, what are you talking about? The proof isn't even presented. There's no proof. You're talking about something that should have been on day 5 of the lawsuit. Oh my god.
Of proof required here is, if it's preponderance of evidence, then I think there is something where like it's getting close. You could make an argument that there's reason to believe that he did this after the fact. If it's beyond a reasonable doubt, if you need to know that for sure, then okay. It is, well, I assume a civil case is preponderance of evidence, right? And now basically it comes down to, what do you think is more likely? That Abby hacked this guy's computer, went through all of his DMs, found like videos that she couldn't have known existed? Or is it more probable that he sent them? And in that case, I feel like if you're making that argument, if that's what the argument comes down to, you have to look at the fact that this guy's sent a bunch of other people's shit without their consent, right? Like Melina said as much. Stasio said as much. There are other people who have said that this has happened. So again, I think preponderance of evidence-wise, I think there's every reason to believe that he sent this video to Abby. But I don't know. The judge will decide there, right? It just seems odd to me that you'd argue like it hasn't been proven beyond a reasonable doubt, where you have this person divining these sex tapes' existence with no evidence, like no
Can you imagine quitting your fucking software engineering job for this? You quit your software engineering job for what? To make money off of hating Destiny all day?
Oh, sorry, divining these sex tapes' existence with nobody saying anything about them. That she just made it up perfectly. Didn't miss, just made it up and got it perfect. Melina saying he did it too is nowhere in the filings, right? Well, it's not relevant until you are saying, well, we believe there's no evidence of this. And it's like, well, the evidence is somebody giving testimony, somebody having contemporaneous logs that show that this happened. That show that they were sent this stuff, right? And then basically Destiny's argument is, well, and you don't have the logs. Me deleting the logs, that's actually, like, you don't have any proof, right? And he's arguing, I believe, that he doesn't have to produce his own logs with Abby to show that like, they would have needed their own side of the logs to basically say, no, we've proven, like, for a fact that it was sent at this time.
Yeah, I wonder how much Tylenol Jstlk fucking guzzled before reviewing anything Destiny related. Oh my god, the fucking anti-fans are just like fucking sad now. Like, they were more fun when they were like actually like more intimidating, but now it just feels like this is just sad shit right here. I hate Jstlk. Why does he have such elite music taste? I glazed his music taste before, but the thing is that like it seems like this is the only genre of music he likes. Like, why does it feel like the only genre of music he likes is like synthwave? Like, does he really not like any other genre of music? Because I feel like at first I'm like, oh well, oh hey, he had pretty good music taste. But then at some point I'm like, bro, we've heard this for like the billionth fucking time.
That declaration and see what was done there, because we read it on stream, right? Shut up, Candace. It has come to my attention that in paragraphs 17 and 18 of my October 3rd, 2025 declaration, docket 139.1, I made a conclusion of tampering based on defendant's incomplete and faulty document production. These documents were produced by defendant on September 12th, 2025 in response to plaintiff's request for documents. Certain of these documents were also submitted to the court in support of defendant's motion to dismiss. The issue addressed in paragraphs 17 and 18 pertained to a Discord direct message from Rose on April 9th, 2022, 8:33 p.m. Eastern, stating that Rose had viewed the video, which defendant did not send her until 3 minutes later, thus physically not possible. The message was one of two displayed with a single timestamp of 8:33 p.m., with the first message acknowledging that Rose would love to see the video. See supporting images below. Yeah? What occurred is that Rose received the video at 8:36 p.m., viewed it, and sent defendant the second message sometime between 8:37 p.m. and 8:39 p.m., and it was timestamped with the correct time. However, on the Discord viewer and exported HTML messages, the defendant used Discord Chat Exporter. Its timestamp by design was hidden, timestamp grouped, and combined with the first message's timestamp of 8:33 p.m., which again led to the sign of potential tampering. The timestamp grouping occurs when a user sends multiple messages, so he's going to explain this. We called this out right away. We just said this is obvious that it's a timestamp grouping thing, that was like a silly thing to say. It's important to note that the exported Discord messages produced by defendant in response to plaintiff's document requests, the ones submitted as exhibits in support of his motion to dismiss, that fell into the category of timestamp grouping are all missing the child message timestamps, key metadata. The defendant produced a single PDF document with approximately 2,400 Bates stamped messages. SB, oh, I see. Along with attachments, but did so without a standard e-discovery load file that would contain the images, natives, extracted text, and metadata, which would have included the child timestamps. Bates stamping HTML documents is not a standard e-discovery workflow when producing documents, thus, the defendant's counsel produced a single PDF document from the HTML version defendant provided to them. The chat files are PDFs created from HTML exports that Mr. Bonnell sent us for production. See Exhibit 1 herein, letter from Andrew Bretler to Joan Peters, Carlos Garcia Perez, September 22nd, 2025. Again, the only issue is that it stripped the child timestamps from the group messages, and the plaintiff is missing important chronology metadata. The concern now is that plaintiff has failed production, which cannot be relied upon or remedied, and presents an ongoing issue with respect to further discovery reliant on any data from what the defendant preserved, unless defendant can demonstrate that he generated a digital fingerprint of the preserved exported messages and any other preserved ESI, electronic something evidence at the time of preservation. The defendant stated in his declaration, paragraph 21, docket 42.1, that after preserving, he deleted the video and unauthorized published content. Thus, any attempt to go back to the original sources containing said deleted content would equate to working with spoliated data and not reliable. Moreover, working with the exported preserved data that was not digitally fingerprinted at the outset cannot be authenticated and validated because running a cryptographic hash algorithm would produce a value corresponding to today's date, not the date at which the data was collected. Therefore, there is no way of determining if the data was altered after the preservation. So this is true. This is true. Obviously. I don't know. I've heard Desi disputed this and said hashes are worthless. That seemed odd to me, like a very odd thing to say. But I don't know. We'll go through. We'll see. We'll see what's up. So the amendment only affects paragraphs 17 and 18 of my original declaration. The remainder of my October 3rd, 2025 declaration remains the same. Okay. That seemed way less important to me than before. Why is this untimely, by the way? How long do you have to amend, like, expert testimony? Oh, my bad. My bad. That's fair. That's fair. I'm giddy, okay? I'm reading.
Does anybody know whether or not, like, Jesus Panea is even, like, a fucking real person? Because I'm not even sure if this person even exists. Does anybody know? Like, is this person actually even a real person?
I like reading. All right. Let us continue. Okay. Plaintiff has failed to establish subject matter jurisdiction. Whereas here, a defendant mounts a meritorious factual challenge to jurisdiction under Rule 12b1, the burden shifts to the plaintiff to establish jurisdiction by competent proof. See Cohan versus Texas Roadhouse Holdings, LLC, dismissing complaint where plaintiff failed to offer affidavits or testimony after notice of factual jurisdictional challenge. Plaintiff must respond to a jurisdictional challenge with admissible evidence, not speculation, to sustain jurisdiction.
I thought for expert testimony, I had to swear under oath or something. I guess apparently not for this one. I don't think this is officially expert testimony, though, right? Like, for Jesus Panea, I don't think that was under, like, official I don't know. This shit is stupid. I don't care. I actually just do not care, actually.
I believe the...
I gave up. I gave up.
If I'm not mistaken, the actual,
anymore.
what do you call it, the affidavit,
This
right?
shit's stupid.
I believe that is considered evidence, right?
You know what covering this feels like? You know what it feels like to cover this? It feels like covering the Thorpe family. Like, that's what it feels like. Like, what it feels like, it's like I'm covering the Thorpe family, and I know that everything is fake and nothing will matter in the end. And this is all just a fucking bunch of bullshit that we'll forget about, like, fucking 2 years down the line. And it's just like, it's just fucking bullshit. It's like all of it is just like complete fucking kangaroo court. Like like a fucking banana case. Oh my god. It's like the most fake drama ever. Like, you're trying to create drama for the sake of creating drama, right? Like, that's what Pixie is doing. That's what Pixie's team is doing. And then everybody is like pretending as if like this is real fucking shit that is happening when it's the fakest shit I've ever seen.
We'll see.
Love to see it, I guess.
The response was due today, so they only had like 2 days to respond, I guess. Interesting. Yeah, I don't understand the idea that this would not be admissible evidence.
Yeah, content farmer
Little
shit,
strange.
sure.
Wee bit strange. Anyway, we continue. The non-moving party may not rest merely upon allegations in the pleadings, but must set forth facts showing the court has jurisdiction. So may not merely rest upon allegations, but must set forth specific facts showing the court has jurisdiction. So I understand how this could be ruled this way. I don't understand in this case how you would be able to get this proof without being able to go through discovery, right? Like, the allegation is Desi shared this stuff, and then he deleted his messages with people before they could file for discovery, before they could get access to anything on his end. So if he just deleted this stuff, then the person who is giving them, you know, this testimony, so like, I deleted faster than anybody could check their DMs, therefore, you're, like, whatever you did, doesn't matter. Is that really, can you do that? Because I guess if you need like the leak in the same way that the Rose leaks happened, if you need that level of evidence, but within the timeline, then maybe you could say it can be dismissed. He also deleted them. Well, he's going to argue that he didn't have to keep it in the original place. But then I think man, that feels like playing with fire to me, but it does seem odd that he was able to just delete stuff from Discord like this. But again, there's some arguments from the original.
That literally does nothing, okay? I can't believe, like... Okay, whatever.
Judge basically like, oh, well, you should be able to delete the video because you don't want the video to be re-leaked.
Doesn't Discord delete records after a bit anyway? No, I think that's after you delete them. Like, after you delete them, they retain it in their database for a little bit, and then they, like, fucking permanently delete them after a while.
Now, here's what I will say, okay? And I haven't seen Pixie's team make this argument, but I believe that Destiny did not delete the videos until November 29th, until they were leaked, despite being made aware of the compromised account. Now, that, to me, would 100% constitute, and despite knowing he had sent pornographic content to this person. And so, I don't know if that November, I believe, 24th to 29th period could be used as a precedent for, hey, you waited until these things got leaked publicly to delete them? How do we know when the export was made from the Rose person? Like, what if they hadn't exported everything? Hadn't exported all of the videos?
Random question. Foodshops was the wildest thing you would do for donations? Well, I had OnlyFans once, so I guess that's the wildest time.
Like, what if we don't know that? Anyway, despite being on notice of a jurisdictional defect since the beginning of the case, plaintiff has failed to submit any evidence of Benel's alleged post-Cardi transmission of the video. A. Dismissal is warranted pursuant to 12b1. In her opposition, plaintiff relies on Lawrence v. Dunbar to argue that dismissal under Rule 12b1 is precluded because the jurisdictional facts are intertwined with the merits of plaintiff's claim. Yes, so this is the thing. Yeah, I thought this was true. So basically, like, if this thing exists, this is like the actual question being asked in this case. Is like, hey, I have somebody alleging this happened, right? After the timestamp. I have somebody alleging this happened. They've produced...
Dude, just by the way, I just want to say that Queenman has moved on to British politics, okay? Like, nobody is doing this anymore except for Jstlk and some of Queenman's orbiters, okay? Nobody is covering this shit anymore. No anti-fan. It's like the only person who's keeping this alive right now and can't move past it is Jstlk, okay? Like, he's so sad and so pathetic. Oh my god. Ugh.
Contemporaneous, like, some evidence of this happening. And if this were true, the case is over. It is, like, over in Pixie's favor. Like, it is totally intertwined with the merits in this case, in my opinion. But maybe I'm misunderstanding what intertwined with the merits means. A plaintiff's claim. They are not, and in any event, Lawrence expressly holds that federal courts have the inherent authority to resolve factual challenges to subject matter jurisdiction under 12b1 unless the factual challenge implicates an element of the cause
and I
of
guess
action.
Hassan, sure, why not?
ID. So citing this case, the date of the trans. So further, the 11th Circuit has emphasis added implicates an element of the cause of action. Oh, they don't say the thing that happened in Lawrence. Further, the 11th Court has declined to make such determinations where the disputed fact, e.g. the date of a transmission of the video, is merely a threshold question to the applicability of a federal statute. Yeah, my bad. See, Honesty, Marine,
You can hear Cherry in the background. Like, she's probably holding like a whip over him, and he's probably super into it. And she's like trying to get him to like fucking cover this constantly. And dude, what if Jstlk is a victim? What if Jstlk is a victim now? Oh my god, it all makes sense. Jstlk is a victim of Cherry. Oh my god, can we please free our ninja Jstlk?
Exploration Inc. versus unidentified shipwreck vessel.
Legal mindset.
How did somebody defend as unidentified shipwreck vessel? What? Are we seeing this? See, Odyssey Marine Exploration Inc. The unidentified shipwreck vessel.
Sense now.
What? What the? Seems bizarre. Okay. Although plaintiff contends the motion to dismiss implicates the merits of the underlying claim, that a lack of subject matter jurisdiction bars a party's claim does not mean the jurisdictional question in it is itself related to the cause of action. That's not what they're arguing. What? Lack of subject matter jurisdiction bars a party's claim. That's not what their argument is, right? I don't think that's what their argument is. Implicates the merits of the underlying claim that a lack of subject. So they're basically saying that it can't just be that because your case will be thrown out unless you can resolve this. Like if this is unresolved, it doesn't mean that itself means it's intertwined with the merits. But I don't think that's the entire thing here. I think the proof they'd be looking for, that wouldn't just be proof of the timestamp. It would be proof of the video being sent. It would be literally the thing, the action, the relevant like element, right? Unless the factual challenge implicates an element of the cause of action. I think it does, right? I think it does implicate an element of the cause of action. Does it? Wait, does it not? What? Dude, I need another lawyer here who can use lawyer brain with me. Okay? Because it seems like... So one of the elements would be to, like, disseminate this, right? it seems like one of the elements would be to disseminate this video, to transmit it in some way. And basically you're getting into whether or not he transmitted it to the specific person. Yeah, litigious gamer, you're who I'm looking for, okay? Would you not say that this factual challenge, so they're not in any of its Lawrence?
Wait, hold on. How do you know any of these people are lawyers? Like, what? Like, are these just like fucking random ass people appearing in his chat and they're just like gaslighting him into thinking they're lawyers? What? Like, what? Like, have you seen any proof that they're lawyers? Like,
Lawrence expressly holds that federal courts have the inherent authority to resolve factual challenges to subject matter jurisdiction under Rule 12b1 unless the factual challenge implicates an element of the cause of action. Would this not? This is very strange, to me at least. Anyway, okay. Contends the motion to dismiss implicates the merits of the underlying claim that a lack of subject matter jurisdiction bars a party's claim does not mean the jurisdictional question is itself related to the cause of action. Yeah, but they're saying, like, literally, you transmitted this thing. You are, as a part of this claim, there's another instance of you transmitting this video. Now, they could say, what could they say? No, I don't think they could say anything. If they were trying to say, this might actually be good evidence, though, unfortunately. This might be good evidence for why the resolution of the timestamp for the original video sent to Rose, like, the court could rule on that, and it would be as a part of it would be a part of everything they're doing to rule on that, because with that one, that is merely like a threshold question. It is like, oh, does this fall within the case timeline or not? Like the law existing, does it fall within that or not? So I do think they'd be able to resolve that, and you couldn't say, well, that actually fucks with the merits of my case. And it's like, no, just fucks with whether or not this is actually like within our jurisdiction.
If that was the case, they would have already presented it. If that was the case, I feel like that would have already been presented. Like, why the fuck wouldn't they present like the evidence from the get-go? Like what is the reason for holding back the evidence, I guess?
Yeah, interesting. So I don't think this actually works for the Abby stuff. It would work maybe for the Rose video, possibly. Okay. All right. By the way, I'm not a lawyer. This is not legal advice. I'm not trained in this, so I'm just giving you my best impression here. The date isn't an element, is what he is saying, I'm guessing, and Abby should be disregarded. But Abby's not making the allegation that it's the date. Abby is making the allegation that the video was disseminated. That is an element, right? The video was disseminated to her. If this was only standing up on the date of the timestamp being like unknown and it could be resolved like 95% by the court, I think then they could dismiss on the Abby stuff, right? Because there is still a question in the court's eye, they have not ruled yet, whether or not the original transmission to Rose was done in October or April. And I think if that's the only question, they could resolve to April and they could say, we're dismissing this case. But with the Abby stuff, I don't think this actually matters because it does implicate an element of the cause of action. So I think their actual, like, citation works against them. I think. Anyway, we continue.
What?
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 The time of the April 2022 transmission has no bearing
What
on
are you
whether,
even saying at this point? Who knows?
Of Cardi, Rule 12b1 governs and dismissal is proper. So I think this seems fine for arguing with regards to the Rose thing. Is Destiny cooked or what? I guess it'll just depend on like a couple things. I don't know how the court handles certain like disputation of facts. I don't know how the court handles disputes. So basically, there's somebody who said Destiny sent them the video. They have logs of them before the videos were ever public saying, oh,
like this is like that's a comment that's asking for cope, right? Like that is saying, Daddy Jstlk, some copium, please. Did you cook up any copium?
I was sent this video, and Destiny's saying, well, they can't produce logs of me sending them the video. Like, they can't produce the video itself or anything about that. So that's not proof. And it's like, well, you deleted your logs. And her testimony is the logs were deleted before I looked, right? So it's like, could that be like a relevant defense? Like, she's predicted the existence of these videos a year before they were ever released. And then we're going to go, well, but that doesn't count because you were at Destiny's computer once. I think is like their basic argument. I don't know. Destiny's got the same odds of winning as Kamala.
They're trying to, dude. How could you still be trying to grasp at straws when they have offered no substantial, when Abby MC couldn't produce a single flying fuck of a piece of solid evidence that shows that the video was even transmitted? Why? Why? Huh? Really?
Harris did. I don't know about that. Like, I think overall, it's still going to come down to whether or not he sent this video. I think probably it's going to be quite difficult for them to convict him or not find him liable if Abby's contemporaneous logs are the only piece of evidence. If they can't get discovery and find additional evidence, I think they would have a hard time finding him liable in this case.
Yeah, but that's what they're doing. They're fishing. Is fishing good? They're fishing, right? Like, I mean, it's not like you deny it, right? Like, they're fishing, right? You realize that you're not supposed to do that, right? The term fishing expedition, right, it's called a fishing expedition. Okay. A fishing expedition, this is from Cornell Law, okay? Let's just read this really, really quick, okay? It'll just take a while. A little bit. Fishing expedition refers to someone overly investigating or demanding information. This is kind of like a cancellation campaign, right? From an individual or organization, right? Like online wise, you kind of want to fish for information constantly, so then you can go after someone, right? Like your let's just say that something bad has happened in a particular case of like a public figure online, so then you're constantly trying to dig up on like past dirt on them, right? You're constantly trying to dig up past dirt on them that's not even related to the original issue. So that's what, like, this happens all the time in like the court of public opinion, which I think is, by the way, rightfully condemned, thankfully, okay, but whatever. In law, the term is but however, there is like guardrails in the court of law that would prevent such a thing, okay? Because there is actually a term here, and it can be recognized as such. In law, the term is most used to describe using the discovery phase of a lawsuit, right, to demand too much information based on hunches and accusations. Discovery allows parties to demand a very large amount of information from one another that can be sensitive information, and these tools can be very destructive if unchecked. Varying by jurisdiction, courts have procedures in place for parties to challenge unruly discovery requests from opposing parties, right? So basically, like, you can't just grasp at straws to look for another accusation in order to dunk on them, right? You need to already have the original accusation in mind, and with that original accusation in mind, be able to ask for evidence related to that specific accusation, no other accusation, right? If you make another accusation or something, I would imagine, and this is just a guess, I would imagine that's not allowed, or at least that's highly frowned upon and could get your case dismissed, right? So, yeah.
Even if jurisdictional facts were intertwined with the merits, plaintiffs still cannot survive dismissal under a summary judgment standard. Odyssey Marine 657. Oh man. Again, I think there is reason to believe that he didn't delete these videos until November 29th. Right?
Wow.
Anyway. Yeah, I think there's some argument in there that they have not made here, but I think they haven't gotten discovery that they would have wanted yet. So we'll see. Maybe they have discovery on all the Abby stuff. We'll see. Okay.
Same reason cops need probable cause for a warrant. You don't want them to search random shit. Yeah, exactly. Yeah. Because otherwise people just can just fucking go around and demand like random fucking pieces of evidence. Yeah, I don't know. Yeah.
Okay. So plaintiff still cannot survive a dismissal under a summary judgment standard. When the jurisdictional basis of a claim is intertwined with its merits, the court should treat a Rule 12b1 motion as one for summary judgment under Rule 56. Plaintiff cites no evidence establishing a genuine dispute of material fact, and critically under Rule 56, a non-moving party's failure to submit any evidence establishing a dispute of material fact warrants summary judgment and dismissal. I think there are still several disputations of fact. I think they've actually disagreed in a couple places, right? I think so. We continue. So the non-moving party has failed to establish a genuine issue of material fact because she has failed to cite a single piece of record evidence in her response. I don't think this is true. Yeah, I don't think so.
Why?
There is no dispute that the transmission of the video to Rose...
Wait, why? Okay.
preceded the
I mean, I guess we're just
effective date
glossing
of
over
Cardi.
it.
The evidentiary record, including Rose's leaked
Or maybe
Discord
not.
communications
Maybe I'll come
log,
back to it.
conclusively, communications log conclusively establishes that the video was transmitted to her in April 2022, nearly 6 months before Cardi took effect. Plaintiff has submitted no evidence to dispute that fact. Rose's side of her communications with Benel was accessed and leaked by a third party who, being located in a European time zone, is not true, downloaded the messages such that the timestamps are reflected in European day, month, year format. I would assume every single Discord exporter could just let you tweak the output timestamps. Like, there's no reason to think these things don't just let you format what timestamp you want on output. The leaked Discord log shows the message dated 10/4/2022, meaning April 10th, 2022. ID, or example, Benel's own logs confirm that the video was sent on April 9th, 2022. In her opposition, plaintiff submits no evidence to the contrary. Plaintiff's ever-evolving continuous disclosure theory fails as a matter of law. So this is another point. And I would say that probably, oh man, this is why, fuck, I don't know, we have to keep reading, but they should have been making the argument about him not deleting the videos immediately. They should have been making that argument the whole time. In her amended complaint, plaintiff alleges, without any factual or legal basis, that Benel transmitted the video to Rose via a Google Drive link, and that such a transmission somehow constituted an ongoing dissemination or continuous disclosure of the video, sufficient to establish subject matter jurisdiction. Thinking about compliance here. I don't know what this is. AM compliance. These are some rules that they cite in courts. Now that the record affirmatively demonstrates that Benel never sent the video using Google Drive, see this declaration, plaintiff has abruptly modified her theory in her...
I'm gonna sue Foodshops for being so stylish. I'm entering her scarf thingy as evidence. Exhibit A.
Her opposition.
Thank you.
Has now abruptly modified her theory. In her opposition, she now concedes that Benel transmitted the video on one occasion via Discord in April 2022, but she asserts that even a private one-time media attachment constitutes a continuous disclosure under Cardi. Plaintiff's ever-evolving theory is entirely unsupported by law. Critically, federal courts have repeatedly rejected similar arguments. In Ray v. Greenberg,
I'm pretty sure Pixie's argument is literally like Pixie's side is literally arguing, I know that there is no precedence. But it's a new law, right? So, how about we become the first? That's literally their argument. That's basically what they're saying, okay? Like, I'm pretty sure they said somewhere, oh yeah, let us become the first. Let us become the pioneers in this field. Let us become the first, okay? We can do it. We can become the first.
oh
wow!
The public link to a shared drive to a single link to a single person where no facts suggest the link was widely disseminated.
Let us become
could not, as a matter of
precedents.
law, constitute an ongoing or public disclosure. The court in the companion case, Greenberg Ray, reached the same conclusion. Plaintiff's attempt to rebrand a single private Discord message as a continuous dissemination is baseless and should be rejected. So with this, this is a slightly different case. So the argument I've seen against this is basically, well, actually under Cardi, you don't need to do public disclosure. So basically, these were about public disclosures. Cardi is not about public disclosures explicitly, right? It's just if you make it available. So because Cardi's not about public disclosures, it doesn't have to do public disclosures. It's making it available to anybody or sending it to anybody. That wouldn't, the standard for the law they're suing under here is about public disclosures, right? So they're saying as a matter of this case, one of the elements, you doing a public disclosure, we do not believe this matches a public disclosure. Don't post the screenshot, so it's a link of the, yeah. So that's the argument they've done against this. Moreover, plaintiff's reliance on Doe v. McCoy is of no consequence. Unlike the public postings in McCoy and Unknown Party, Benel neither uploaded nor publicly displayed the video online or in a public forum. Nothing in McCoy or Unknown Party suggests that a private Discord attachment amounts to ongoing disclosure by the original sender. Indeed, no court has ever held that a one-to-one message, especially one sent before the statute's effective date, constitutes an ongoing disclosure under Section 6851. Plaintiff fails to submit any evidence that Benel ever transmitted the video to ABMC. Plaintiff likewise offers no credible evidence that Benel transmitted the video to ABMC at any time, let alone evidence that could establish a genuine dispute of material fact as to such a transmission. Indeed, Benel's preserved logs show every file he sent to ABMC, none of which contain the video. See this declaration. While plaintiff merely alleges Benel transmitted the video to ABMC sometime after March 2023 via a Google Drive link, the evidence conclusively establishes such a transmission never occurred. Literally, they could have totally fabricated this evidence, and there's no possible way to know that, right? So let's say if this person were operating in bad faith and they were just fabricating this stuff, is there no way for the court to require something? Old 10 alert, Desi crashing out while fixing up his legal case. Nice semi-relevant cleanser. Well, this is not quite the same thing, Maximus. It's
not in line with the quote of light criticism, right?
Oh, dude. Oh no.
And she's kind of, I understand.
I can't believe dates are so fucking gay.
Desi was all pissy about this, right? He was all pissy about his timestamps not lining up or whatever. It's not really fabrication, though, Maximus. This is him being incompetent. Right? It's just him being incompetent in this case. It's kind of expected, kind of understood.
do I just appear randomly on Jstlk's stream these days? Like, bro, I barely even notice.
Benel's communication logs with ABMC demonstrate that the only Google Drive links he shared on November 3rd, 2023, contained videos of another individual, Peach, who has confirmed the content as her own. Plaintiff's contrary allegation rests on speculation, not evidence. See Benel declarations here. Plaintiff's failure to provide any evidence to support her allegations. Also, hold on. Communication logs with ABMC demonstrate that the only Google Drive links were these. Okay. What if she was just mistaken about it being a Google Drive link? Would be the first question I'd ask. Plaintiff's failure to produce any evidence to support her allegations is fatal to her amended complaint. This is just not... I mean, there's evidence there. I don't know. It seems weird that they just keep repeating the same lie over and over again. Also, they should respond with... they should say... I don't know if they get to file any more motions here, but they should post the Peach logs and say that Peach herself has said that Destiny has sent her non-consensually recorded material. Because Peach herself has said that, yes? So I guess if we're going to hold her...
Has her? Has she? I feel like I would have heard about this by now. If Peach really says... Oh yeah, Destiny has sent her like non-consensually recorded stuff. How does she even? How would she even know that? How would she even know? Like, wouldn't it just be like? Wouldn't it just be like? Oh well, I can neither confirm nor deny, right? How do you know this? How does she know this? How does she know this from her side?
Credible, then shouldn't we actually subpoena this person too? I believe this person's logs should be open for subpoena, no? And by the way, actually, maybe their whole machine, because they save a lot of stuff. Which year did Peach say that? 2024, I think. See, Seventh Chakra Films, this the non-moving party has failed to establish a genuine issue of material fact because she has failed to cite a single piece of record evidence. Plaintiff has had nearly 8 months to conduct discovery. Plaintiff's untimely improper plea for further discovery cannot salvage jurisdiction and avoid dismissal. Courts deny such fishing expeditions. I think their plea for further
Is Peach in this? Yeah.
discovery was because the preliminary injunction hearing went so long, right? Like, it took so long for that to go by that they asked for more time to do discovery. I thought this was true. Okay. Courts deny such fishing expeditions where plaintiff had months to develop the record, yet fails to identify the specific evidence expected to emerge. See in re Takata Airbag. Courts should not reserve ruling on a pending motion to dismiss in order to allow the plaintiff to look for what she should have had, but did not before coming through the courthouse doors.
Foodshops is in on it too.
This seems fine, right? But like, I don't know. I assume they weigh this specific ruling. I assume they weigh this against like how convenient is it for us to dismiss this and then have them find that evidence. Let's say they find it through some other means and refile or something. It took that long because Pixie made it that way, though. Yeah, but it's still a preliminary injunction hearing. Pixie didn't make it take longer to schedule or have the hearing or like.
Dude, not even his own chatters are like on board anymore. Like, it's so sad to see. Like, I wouldn't imagine. Like, not even his own even his own chatters are like having doubts. Oh my god, it's so fucking over, dude. It took so long because Pixie made it that way, though. Yeah, well, like why load shit up with random fucking bullshit? Like, well, like what was the point of the fucking extended like fucking fuck, what is it called? What is it called? You say you used to have a OnlyFans? Why stop? Yeah, you would want to know. No, it was just because I got lazy. Like people, I don't know if you know about this, but like you still have to like put work into your OnlyFans, even if you want to like get attention there, right? Like even if you're like putting nudes and like fucking weird shit on there, like you still need to be able to, I don't know, yeah. I mean, it's easy, okay? It's easy to do that, but you have to keep at it. When you're doing like content creation, and when you're doing like fucking YouTube and you're doing OnlyFans at the same time, I don't know, I just don't really find the energy to do extra in order to like maintain something. Yeah.
For them to rule on any of the motions, it's the judge. Pixie can't make the judge rule faster. The judge took weeks and weeks and weeks and weeks to rule. It was only a few weeks ago Pixie filed something asking the judge to hurry up because they're running out of time. Oh yeah, they actually did a motion like, hey, can you give us a ruling here? What the fuck's going on? I see.
To be fair, like the 1 month that I had OnlyFans, I think I was earning $1,000. Yeah, I think was it $500 or was it $1,000 in a month? For the record, like I had much more of a I had much more of an advantage because I was also advertising my OnlyFans on my YouTube. So, pretty wild, but hey.
Stevens BS is why these initial phase steps are taking so long. Maybe. I'm not totally sure about that. I think the judges, the judges seem kind of overloaded, so. Okay. All right. Let's keep looking. For me, denial for general request for...
That was when I had an OnlyFans account for shits and giggles. So I had an OnlyFans account for shits and giggles. And yeah. At that time. But then I turned it into a serious account down the line.
Jurisdictional discovery raised months after filing the complaint. So they literally said, hey, could you hurry up? Because we're waiting on...
Wait, do you not remember? Do you not remember what went down back then? What went down back then was that, like, the reason why Karantos and the other panelists were so mad at me was because I wasn't actually a sex worker. Like, I had an OnlyFans account, technically speaking, but I didn't do sex work on there. So technically I fulfilled the requirements of the panel. Like, it still fulfilled the requirements of the panel, which is why I managed to get on. So it was funny, okay? That was funny.
I thought there was already a whole conversation about this that had happened, if I'm not mistaken.
It was epic.
Plaintiff cannot now avoid dismissal due to her own lack of diligence. Apart from issuing a subpoena to Kiwi Farms early on in the case, plaintiff has done very little in an effort to establish jurisdiction. She has failed to take a single deposition or even elicit testimony from her purported star witness, Abby MC. So I'm guessing Destiny subpoenaed Abby MC for like a deposition now, right? Because he had never, in the past, he was mad that he couldn't serve Abby, but he wasn't trying to serve Abby a deposition request, right? He was trying to serve her with a notice to produce documents.
Oh, nice.
So I assume they'd also include that they have actually, tried to subpoena her and ask her questions, right? In fact, plaintiff has obstructed Benell's access to Abby MC despite... So did you give them a thing that's saying you wanted to ask questions? I hope so. Okay. All right, we keep looking. Moreover, given that Benell has already produced all responsive documents in his possession, plaintiff has failed to articulate what...
There's not a moment on this planet where I could stand to listen to Karantos. Well, lucky you, okay? Because for most Kick or Keep episodes, especially later on, Karantos is actually fucking sleeping. Karantos is actually fucking napping, alright? For all these, like, fucking episodes. Because even Karantos was fucking bored of the job, alright? He had no passion, no drive to do it. By that time.
What further discovery she supposedly still needs. With the discovery deadline looming, plaintiff is now scrambling in an attempt to establish subject matter jurisdiction. In just the last few weeks, plaintiff has begun noticing depositions, retaining purported experts, and even trying to obtain irrelevant materials from Benell's ex-wife, who now resides in Sweden through the Hague Convention. Plaintiff's lack of diligence is fatal to her claims. I mean, there's another side to this, which would be, I assume, something like this. Like, hey, we need this motion to go through. If there aren't challenges to Abby's testimony, like, we have our subject matter jurisdiction and we can continue this normally. Oh, they're going to challenge Abby's, like, subject matter jurisdiction. Oh, we thought this was in October. We legitimately thought it might be in October. Oh, fuck. We need to go find this stuff now. Like, we have to ask some of these other people. That would have been very expensive to do. Like, I assume trying to subpoena somebody in Sweden is not cheap. I assume that costs money. So it's like, oh, we think we can continue on with our case. And then they're like, oh, fuck. Well, now it's...
I mean, does it? Like, why are you just, like, running with this? Like, nobody with any sense would consider this to be, like, a normal act. Like, hold on. Does it cost money? I'm just half listening to Jstlk, to be honest, because he's so fucking boring. Does it cost money to subpoena international? And this is while I'm on ADHD medication, by the way, okay? Not even, yeah, subpoenaing internationally costs money, which includes U.S. court fees. The U.S. Embassy? Okay, so it's fucking expensive. What? Why would you? Oh my god, just kill me, dude. It's so stupid.
Taking a long time to go through this, and this is denied or something. So maybe they are scrambling to some extent, but they're probably waiting to make sure they could go through without having to spend a bunch more money. Now, that might be one of those cases where, hey, you're a poor person. Get fucked, loser.
It is common knowledge that evidence quality deteriorates over time, which is why lawyers try to get information sooner rather than later. Maybe people delete documents or forget. Wait, another question is, why the fuck are they trying to subpoena or trying to fish this late into the game? Why the fuck, like, during the discovery process, like, why the fuck are you trying to fish information from Melina this late into the game? Shouldn't this also be critical evidence? Also, if Abby MC is such a star witness, why the fuck would you go after Melina, right? Shouldn't Abby MC be enough? It's almost as if, like, you actually decide that Abby MC is not enough. It's almost as if, like, you know that Abby MC is not enough. It's almost as if, like, you try to fish on purpose to extend the length of this fucking case. Right? Like what you're doing is that you're just, like, extending this. That's all you're trying to do. You know that would extend this, but you know that it won't work. Like, it's so stupid. Oh, wait, hold on. Abby MC is our star witness, except she's not, I guess.
I believe they have evidence to this fact, like, pointing towards this fact. I think it's insane as well. Like, obviously, I don't believe it's sent in October. But I think they felt like they were confused. Now, is that feigned ignorance? Maybe. Unfortunately, that's sort of the same level of feigned ignorance where Destiny goes, guys, I felt really bad that the videos leaked at all. That's why I said I broke her trust. I violated her trust in the most egregious way possible. Because, like, I just felt bad that something totally expected happened. Right? It's like the same level. I don't know. I have a hard time feeling, like, super bad for when he's done that already, you know? Plaintiff's reliance on Jones v. Waffle House and Eaton v. Dorchester is misplaced. In each of these cases, the motion to dismiss was filed at the outset of the case before the plaintiffs had any meaningful chance to obtain discovery. These cases do nothing to excuse plaintiffs' 8 months of inactivity. I don't think this is a problem. I don't know. I think they basically talked to people about getting an extension on the discovery or to pause discovery until the motion for preliminary injunction was gone through. Anyway, plaintiff's baseless allegation of evidence spoliation has been repeatedly rejected by the court, and the Pena declaration should be stricken. Rather than submit evidence to establish subject matter jurisdiction, plaintiff instead filed a declaration from a purported expert who falsely accuses Benel of evidence tampering. The court has already rejected such a contention on multiple occasions.
It is fucking Melina over. Dude, I can't believe it, dude, but, like, I just want to say, okay, I just want to say, how could you possibly pretend you're doing any of this on the behalf of women and women's rights? How could you pretend this? Like, how could you possibly pretend that you're doing this on the behalf of women's rights and on behalf of victims? Like, that part is the most infuriating, like, most shameless part to me. Like, that is so shameless. It's so shameless. Yeah. Like, I don't even know, like, even if I was going scorched earth, I don't know if I would have it in me to do something like that. That's crazy. That's insane to me. Okay. But yeah, you know.
I think they just said you didn't produce evidence of this, or that you should file a motion for it. I don't think they reject
Actually,
things that are
I
just
think if you go
allegations.
scorched earth, you wouldn't care about other women, which is fair enough.
I don't know. I think
yeah,
so.
I don't think you care about other women if you go scorched earth. Whatever.
Anyway, order denying motion.
You watched Destiny cover / watch the filing earlier today? No, I haven't, because I don't know. Like, I just don't really feel any need to go over what I've already gone over on my own time. I don't know. Like, yeah. I swear to God, it's not a I swear to God, it's not a fucking ego thing. It's like there's just no point. Like, why would I go over it again?
Why wouldn't you? Why would you not want a technical expert to weigh in on, like, how things are being done? That seems completely insane, but okay.
What?
Subject matter.
Because the arguments are fucking stupid. I mean, it's okay if you want to do that, but, like, did Huizu Panea do it under oath? Does anybody know whether or not that person did it under oath? Because no, I don't think so. There's no way he did it under oath. Because the thing is like, why the fuck would he correct the statement later on if he did it under oath? I like, what's the reason? The only identity they put effort into protecting and not fucked it up is Pixie. They've leaked Abby MC, Quayman, and even Jstlk. They gave the full name of Melina. They're either completely incompetent or don't give a fuck about anyone else. Yeah, sure. True.
Jurisdiction is a threshold issue that should be.
But it's wrong, though. It's not even correct. But it's wrong. Like, I think that, like, I can totally acknowledge, listen to me, okay? I can totally acknowledge if Kiwi Farms manages to come to some, like, conclusion, and then, like, at the same time, the federal court or, like, some fucking courtroom also comes to the same conclusion. But the thing is that, like, it's wrong. They're both wrong. Which implies you don't know what the fuck you're talking about.
I don't understand how this could possibly work on somebody after the
So there's a bad argument on the internet, okay? And you copy and pasted the bad argument on the internet to your court case, okay? You're telling me that we're gonna coincidentally have the same fucking bad argument coincidentally twice, even though everybody knows about Kiwi Farms and they literally link to Kiwi Farms directly? Really? That's crazy. That's crazy.
Apple's manifesto, but he didn't source it, did he? Why do you have to source it? Well, why?
Dude, even if it was correct, do you know the astronomical odds of any 15 words together being the same? For the record, I mean, it really depends on which 15 words you're talking about.
Why would you have to source?
For you're talking about network competency, okay? You're talking about a fundamental understanding of URLs and links, okay? That is being misunderstood, all right? This isn't 2 plus 2, okay? It's 4 equals 6 minus 2. Okay, that makes no sense. Okay, the point is that you're not putting 2 and 2 together, okay? You're like saying 2 plus 2 equals 5. And then you're copy and pasting your friend who is sitting next to you, who is writing 2 plus 2 equals 5, and then you guys both get it wrong on the test. That is what is going on here, okay? You guys are both trying to solve a problem for a fucking exam or some shit, and then somebody writes like 5 plus 5 equals 11, and then you copy and paste their answer. It's a 5 plus 5 equals 11, and then the professor is like, okay, well, you guys both got it wrong, but I can tell you guys cheated, so I'm also going to punish you guys for cheating and getting it wrong at the same time. You can't just say, well, how do you know I didn't arrive at it at my own fucking conclusion? And the person who just happens to be sitting right next to me also arrived at it at my own fucking conclusion. This is fucking retarded.
Allegation that he can't even make. But it's like, I wouldn't use that because it implies something that I don't think is happening. This is just incompetence in copying. Telling you his claim today about the Kiwi link. Oh, I see. Okay. Yeah, sure. Okay, hold on. Mr. Pena submitted this. Worse, while Mr. Pena attempted to conceal his actions by removing the hyperlink destination on one of the embedded images in his declaration, he failed to take the same measures for the plagiarized embedded image on page 13 of his declaration, which still contains the hyperlink destination to the Kiwi Farms post. See Henderson v. Lockheed Martin Corp. Okay. Do you have to... Maybe you have to source these...
Is all of his playlists all TikTok music, bro? Yeah, it is. I think I recognize some of them from watching fucking YouTube shorts. Yeah, I guess we know what he's doing in his free time.
Maybe holding that plagiarism in experts
he's really going through it. He's really going through it.
Holding that plagiarism in experts report warranted exclusion of expert who passed off others' work as his own, demonstrating an unreliable methodology as a whole. So would this be... We could look at this, okay? Henderson v. Lockheed Martin Corp. Would this be like an opinion overall that he would plagiarize, or is it just the evidence, the factual evidence that he copy-pasted from here? He copy-pasted after validating. I don't know. How do you remove a hyperlink from an image? I'm guessing embedded in the PDF file, there's a hyperlink to Kiwi Farms to show the image, where in one of the cases he would have used like a third-party thing, or in another case he would have left the hyperlink to Kiwi Farms in the document. Yeah. But I would say leaving the hyperlink in there isn't really proof he was trying to mislead or plagiarize. I don't know. It's federal law that you're not allowed to cite the farms. Well, that's crazy, man. I don't think that's true. I don't think that is a federal law. Call me crazy. I don't think that's a federal law.
Wow.
Okay. Moreover, just 2 days ago, on October 8th, 2025, plaintiff filed an untimely motion without even attempting to meet and confer with Bonnell's first counsel first, seeking to amend the Pena Declaration, wherein she informed the court that paragraphs 17 and 18 of the declaration were no longer supported. ECF number 147. Mr. Pena submitted an amended declaration, disavowing and retracting certain meritless conclusions of evidence spoliation, particularly as it pertained to transmission of the video to Rose. The Pena Declaration must be stricken and disregarded accordingly. No, he said basically like I looked at this and there's no trail, so there is information that would be required missing here because of the I guess you would say the technique he used to preserve evidence. There are things that are missing that are important, but I do believe that like this isn't proof of like spoliation, which I didn't think it was proof of spoliation either. So. All right, conclusion. For these reasons and the reasons set forth in Bonnell's motion, Bonnell respectfully requests that the motion to dismiss be granted in its entirety. I guess we'll see here, because I don't know, does Pixie get another opportunity to respond? I think this is like where you're going to see if this goes through. Now, nobody thought this was going to go through. I guess you'd have to ask, some lawyer on about how strongly they can rely on witness testimony, right? Because I feel like the Abby stuff is going to be allowed, but that's based on me seeing other lawyers talk about this.
Legal mindset? And the Kiwi Farms lawyer?
Objection. You're snarking. Okay. All right. So that's the whole thing here. I guess maybe. I think the lawyer is saying that the dude just looked at Kiwi Farms without doing his own process that reached the same conclusion. So we don't know if it's his pro opinion. So how can we take this seriously? But what did he take from here, right? It looks like he took these images to show the differences, right? It looks like that's what he did. He just took these images to show the differences. In my opinion, that doesn't mean that it's like incorrect. And most of his most of his like expert testimony is pertaining to other different things. Like this is a very small part of his testimony. Yeah, I'll probably take a look, Raul. I'll probably take a look. Noticing the logs being different isn't a professional opinion. Yeah, this is like something anybody could do. You don't have to be a professional to see a difference between these things.
Ryle Kittenhouse.
Anyway. Oh yeah, you definitely don't have to be a professional to see the difference. Like L1. Yeah. Okay. All right. I think we got some highlights of this guy like speaking out about this. Let's see here.
Or of Cardi, as well as whether or not he disclosed the image to ABMC. Again, how are you going to do discovery on my end for this? ABMC, this is your witness. You should have the information.
Because you yourself said you deleted this and archived it, and you are supposed to be the source of this evidence? Probably? Like if I had to guess. You literally deleted the evidence from the joint record, and I assume you can't just delete evidence from the joint record, this thing that's supposed to be your unimpeachable record, and then never provide the actual record of your communications, right? Am I crazy? Why would that be the case? That you can just delete a bunch of evidence, and you go, well, I deleted it because I wanted to protect her privacy, but also I won't actually provide any of the evidence of these logs. That seems bizarre to me, right? And he's saying, oh, go ask Abby MC for her logs. And it's like, bro, you deleted your side of those logs. Yeah, well, Bragging Dev kept it archived. Yeah.
But the burden of proof is on you, though. Does it even matter? Because when you go into this fucking court case, you're saying that you already have the evidence on hand. When you go into a court case like this, especially when you try to go through the discovery process, like, I don't think... Dude. Hold on. Does anybody know? Does anybody know whether or not Pixie has issued a legal request towards Discord to retrieve evidence? Discord discloses user data in response to valid legal requests and consistent with the Federal Stored Communications Act. Right. U.S. law enforcement should submit the appropriate type of legal process as outlined by these statutes for the data they are seeking. Like, yeah. I don't think so. Why haven't they? Why haven't they subpoenaed Discord? Or issued any kind of request? Ever? Why? Destiny has said Discord logs only go back 30 days, if I remember correctly, so it's useless. Right, but that doesn't even matter. That doesn't even matter. Because there's no good faith effort on their part to show that they have made any reasonable effort to try to achieve the logs without Destiny handing over everything himself. Discord only holds messages for 30 days. Sure, yeah, but again, right?
Yeah, that seems like talking out of both sides of your mouth, no? Wouldn't that be very concerning to people? That he said, oh, well, the reason I deleted it was because I archived it, and now I have it for evidence for the court case. And he goes, but you should ask Abby with the deleted logs. It's funny.
What are you hoping to discover from me? Why, it's your witness. Why are you asking me about it? What the fuck? Yet, discovery in this matter is far from complete, and the evidence relied on by defendant is not reliable and cannot be authenticated. Plaintiff cannot fairly be required to meet her burden of proof without the opportunity to complete discovery. Because Rule 56 presumes that the parties opposing summary judgment had a fair chance to complete discovery. Blah, 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 blah.
Okay, I don't know where he's... I don't understand that contention there. I understand why you have to signal that to DGG to try to paint yourself as a victim, but I don't understand that contention. You've deleted their side of the record. You say you archived it, and you go, well, why do you want my side of it? Why would you have any right to my side of it? Well, because you deleted that stuff. And the whole way you avoid spoliation arguments is by providing that record, right? That's like the joint record.
This is such a stupid fucking thing. Because I bet by now, lots of people's fucking court cases are dependent on, like, Discord logs, right? Like, I bet, like, there's at least one, like, over the past few years, there have been several civil litigations. In fact, I would guess, like, there's...
This is the dankest dungeon.
Yo, hey, sleeping buddy. Thank you so much for the 5 gifted subs. I appreciate that. On Kick? I appreciate that, buddy. Thank you. But yeah, again, it's just... Destiny's Kiwi Farms thread didn't make a template for the Discord subpoena, so they had to forgo it, unfortunately. Oh my god. The proper action was for her lawyers to send a notice to Discord back in January. They should have hustled. They should have hustled to try to, like, take the fucking evidence before it's being deleted within that 30 days. Like, what the fuck? I mean, that's not an excuse. I'm sorry, but that's not an excuse for your fucking incompetency then, right? And that's even assuming incompetency is a thing. Right? Because that's assuming they're stupid and the worst fucking lawyers on planet Earth. To not try to hustle and try to get as much evidence as possible in the first fucking month. Like, what? Square this for me.
Otherwise, I think he would have deleted it after being aware of the lawsuit, and that is literally spoliation. If he's deleted something in a joint record after being notified not to, and he says, well, I'm allowed to do that to protect my privacy, then I don't see how you could say, well, I'm allowed to do that to protect my privacy, but I'm not going to provide those records to them? Is that not totally broken thinking? I don't know how you could possibly support that, but maybe I'm crazy. Seems like completely broken thinking. Very interesting. Okay, why are they doing this to me? Why are they doing this to me? Why?
Assumption is they're just trying to make this claim so that they can push this case out for as long as they possibly want. But, like...
Hold on. Discovery closes December 16th, 2025. See Order ECF 23, but it is still in early stages. Written discovery is ongoing and depositions have not yet been conducted. Written discovery only began after the court granted plaintiff's protective order on September 2nd. Right! So as a part of the preliminary injunction, they also filed a protective order, and that was only granted in September. So they were basically waiting to try to file evidence and do depositions because they didn't want to expose people's identities. Oh, and he's gonna, like, totally leave that out, right? He's gonna totally leave that out? His propensity for, like, doxing people obviously leading to them going, oh yeah, well, we probably do have to protect these people. Huh. Maybe he'll say that. Maybe he'll be very fair and he'll say, I've been on a doxing, like, spree recently. So, it kind of makes sense that they had to wait for their protective orders.
More or less, they turn over everything they've asked for. They keep asking for, like, broader and broader things. Like, I don't remember if I said this before, but at one point in the early stages of this case, they were saying that they wanted every single image and video that I'd sent and received over the past 5 years. That's how broad that they thought they could do, like, their discovery. This is just like a fucking joke. It's like, this is never happening. You're out of your fucking mind. So they're...
The best part of this is going to be if... The best part of this would be if somebody with, like, a very clear case here comes forward